One.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Clerk. Good afternoon to the attorneys. Welcome to the Tennessee Court of Appeals. Couple of things before we start. If there's any technical difficulties, please let us know immediately so that can be corrected. The second is you will be presenting this case as if you were actually in court, except you will not need to stand to do your presentation. Okay. Mr. Clerk, are there any preliminary matters?
No, Your Honor.
Then will you please call this case?
Estate of Martha Harrison Bain versus John Bain et al.
For the appellant, are you prepared to present your argument?
Yes, Your Honor. May it please the court, I am Thomas Levier. I am counsel for the estate of Martha Bain. I respectfully request that I be allowed to reserve 3 minutes for rebuttal in this matter.
Yes, sir.
Your Honor, we have raised 6 issues in our brief, and I am going to primarily focus on 2 issues for purposes of the oral argument today. The first issue is whether the trial court made an error in setting aside a default judgment that was entered in this case in the year 2009. The second issue that I intend to focus on is going to be whether the trial court was an error in its finding that there was no confidential relationship established between Martha Bain and her son. And we say that the facts show that there should have been a confidential relationship, and as a result, there should have been a presumption of undue influence, which would have arisen and which would have changed the burden of proof in the trial court. This case was, the genesis of this case is a warranty deed that was executed in the year 2003 by Martha Bain in favor of her son, John Bain, as well as his wife, Ann Bain. That deed was executed on October 28th of 2003, but it was not recorded for approximately 3 years. It was recorded by John Bain in the year 2006. Martha Bain subsequently filed lawsuit in the year 2008. There were some attempts at service of process. There was service of process was ordered by publication and was ultimately done by publication. And there was no response by John Bain or Ann Bain. And a default judgment was entered in the case on March 23rd of 2009. That default judgment was in place for a number of years. There was a hearing that occurred before the trial court in September of 2010, and John Bain and his wife Ann Bain appeared at that hearing based upon the order that was entered by the court. Appeared at that hearing. The purpose of the hearing was to address the motion to compel some documents that had been the defendants had been ordered to provide in the default judgment that was entered. They appeared. They addressed the court, and the order reflects that they testified. Nothing happened for over 4 years from that point. The default judgment went down, and then this hearing occurred in September of 2010. And then in May of 2014, a second lawsuit was filed. The first lawsuit involved the validity of the warranty deed, and the warranty deed was set aside as a result of the default judgment. The second lawsuit involved a deed of trust that had been that had been recorded after the warranty deed was signed, but before the lawsuit was filed. And that deed of trust was in favor of Alan and Elizabeth Kingery. And the second lawsuit was primarily addressing that deed of trust, the validity of that deed of trust, and attempting to set aside that deed of trust. At that time, so again, we're over 5 years from when the default was entered, over 4 years from when the defendants appeared in court and testified. They then filed a motion to set aside the default judgment. The default judgment was set aside ultimately by the trial court. There was an appeal that followed to this court. So this case has been in front of the Court of Appeals once previously. And at that point, a number of issues were raised, and the court sent the case, reversed the decision of the trial court and sent the case back to the trial court for a more clear determination, a clarification as to the basis for the setting aside of the default judgment. So in any event, the default judgment was set aside in the year 2014. Discovery proceeded from that point. At this point, Martha Bain was beginning to suffer from serious health issues. The matter was ultimately set for trial in February of 2018. And at that point, Martha Bain was suffering from such severe health issues that she was not able to attend trial. She had not been able to attend all of her deposition. And the trial court ended up moving forward with the trial. And at this point, Martha Bain was 94 years old, but ended up moving forward with the trial, but excluded her deposition from the proof at the trial. And that is one of the issues that we have set forth in our brief. But the issue that I want to address, let me say one more thing. Just to be clear, in the trial of the case, the trial court found that there was no confidential relationship between Martha Bain and John Bain, found that a power of attorney that had been executed in favor of John Bain had never been utilized by John Bain, and so there was no presumption of undue influence. And ultimately, the case was dismissed by the trial court at trial. After the case went back down up to the Court of Appeals and back down, the trial court again found that the original default judgment from the year 2009 should be set aside. What we have presented in our brief and the issues that we're addressing is that there's a doctrine, the exceptional circumstances doctrine, and that pursuant to that doctrine, the court should have taken into account the intervening circumstances and should have left the default judgment in place. Now, the exceptional circumstances doctrine, in essence, has two elements. One is, did the defendants manifest an intent to recognize the judgment? And we say the facts show that they indeed did manifest an intent to recognize the judgment. Where we say that element is met is the hearing that occurred in September of 2010, at which the two defendants appeared and the two defendants testified, and an order went down from that hearing. And they, at that point, did not, at a time when it would have been expected they would do so, at that point, they did not protest the judgment, and they waited an additional 4 years before they filed a motion to set aside that judgment. And then the other element of the exceptional circumstances doctrine is that there must be an interest of reliance. And what we say is the reliance is twofold. And primarily the interest of reliance is the fact that Martha Bain, by the time, now remember when the original warranty deed was signed, she was 79 years old. But by the time we got to trial, she was 94 years old. Her health had declined greatly, and there is evidence in the record that her health had declined greatly during that period of time, to the point where she was not able to fully participate in discovery, and she ultimately was excluded, was unable to appear at trial due to her health, and her deposition was excluded from evidence based upon her inability to participate in discovery. And we say that under the case law and under the restatement second of judgments, section 66, that's an interest of reliance, that she should be entitled to have a finality to the judgment that was entered in 2009, and that judgment should not have been set aside 5 years later by the trial court based upon those exceptional circumstances. So on that particular issue, we say the trial court was in error in setting aside the default judgment as to these two defendants. The other issue that I wanted to address before the court today is whether there was a confidential relationship between Martha Bain and John Bain. And what we say is that the court was in error in its finding that there was no proof that the power of attorney had ever been utilized by John Bain prior to the execution of the warranty deed in question. And that is based on the case law, because under the case law, if there is a power of attorney in place, that sets up a legal a legal fiduciary relationship, and it is a confidential relationship. And then the burden of proof switches. And we say that's what should have happened here. Factually, here's the dates. The dates of all of this is important. The power of attorney was executed on May 9th of 2003. The warranty deed was executed, the warranty deed at question that the plaintiff was trying to set aside was executed on October 28th of 2003. I do want to note briefly to the court that in my original brief that was filed in this case, we put that date as October 20th of 2003, but the record clearly shows that that was an error. That the
Mr. Levier,
yes.
Let me ask you this. I think ultimately what the trial court put a lot of emphasis on was the fact that around this time, this was not the only warranty deed that Martha Bain transferred. She was transferring property via warranty deeds to all of her kids. So why would this particular transaction be incorrect or the result of undue influence when it was clear that it wasn't just that she was giving property to John, it was to everybody?
Well, and you're right. That is what the trial court found. And I'll answer that in two ways. Way number one is there should have been a presumption of undue influence as a result of the confidential relationship. And if so, the burden would have transferred over to the defendants, and it would have been the responsibility of the defendants to show by clear and convincing evidence that this transaction was fair to Martha Bain. So that's the first part of my answer. The second part of my answer is the deeds that your Honor is referring to, the deeds to the other children, in this particular deed to John Bain do not fit the same pattern. Yes, there were prior deeds. Yes, she was giving property to her other children, but that was at her own volition. This was something that was done at the request of John Bain. And the greatest distinction is the other deeds were recorded immediately. This particular deed was held for 3 years, was not recorded, was held for 3 years. And we say it simply does not fit the pattern and does not rise to the level of clear and convincing evidence to rebut what should have been the presumption of undue influence.
You made this statement, but is there proof in the record that shows that the way this transfer of property came about was simply because John Bain went to her and said, "Hey, Mom, transfer this property to Ann and I"? Is that in the record?
My time is up, but may I answer your question?
Please.
Go right ahead.
Okay. I think what is in the record is John Bain himself did not testify that this was a gift to him from his mother. So in other words, the trial court found that this was a gift to him, that it fit the pattern with all of these other deeds, but that's not what the testimony of John Bain was. John Bain testified that his mother owed him money and that this was a transfer to him to replace in place of that money. And we say that is what the evidence, and the evidence conflicts with what the trial court found.
Thank you.
Okay. Thank you. You have your rebuttal. Yes, ma'am.
May it please the court. My name is Rebecca Harbin. I'm an attorney with Branch McConnell and Seymour, and I represent the appellees in this action, John Bain and Bain, the estate of J. Allen Kendry. Responding to some of counsel's comments, he summarized the case well. It began in 2008 with a complaint that Martha Harrison Bain filed against her son, John Bain, and his wife, Ann Bain, to set aside the deed that she executed to him in 2003. In that lawsuit, Ms. Bain failed to join J. Allen Kendry as a party to the 2008 lawsuit because even though he was a beneficiary of the deed of trust that was of record in the Cobb County Register of Deeds. The trial court on March 23rd, 2009, entered a default judgment against John and Ann Bain based upon the representation of plaintiff's counsel that service had been properly effected to bring John and Ann Bain within the jurisdiction of the court. The clerk and master issued a deed to Miss Bain, conveying the property back to her, and the deed is silent as to Mr. Kendry's interest in the property. As I will address the failure to properly serve John and Ann Bain momentarily, the appellant has argued in its brief that John and Ann Bain waived their right to challenge service of process, but because it wasn't presented to the trial in 2018, they've waived this right too. So then in 2014, Martha Bain filed the second lawsuit seeking to set aside the deed of trust in favor of Alan Kendry. John and Ann Bain appeared at this time and moved to set aside the default judgment in the 2008 case. Although they had appeared earlier to challenge a motion to compel payment of costs, that was the only time they appeared in the 2008 case until a 2014 case was filed. The court consolidated both 2014 and the 2008 cases and granted the motion to set aside the default judgment. After years of discovery attempts made by John and Ann Bain to defend against the claims that Martha Bain asserted against them, the matter was ultimately set for trial on the merits in 2018, and Martha Bain failed to appear for the trial. The court at this time found in favor of John and Ann Bain that there was no confidential relationship, there was no undue influence, and even if there was a confidential relationship, they presented evidence that would rebut the presumption. The appellant appealed the first time, and the court determined that the trial court needed to make findings of fact as to the decision to set aside the default judgment. The trial court made findings of facts and conclusion of law that the exceptional circumstances doctrine did not apply and that J. Allen Kendry was a necessary party. So a decision to set aside a default judgment is discretionary with the trial court, and this court reviews it under an abuse of discretion standard. And if any reasonable minds could differ as to the decision to set aside a default judgment, the trial court did not abuse its discretion. With respect to setting aside the default judgment, Tennessee Rule 60.03 does not place any time limits on moving to set aside a default judgment that's void. Our Supreme Court did adopt an exceptional circumstances doctrine in Turner v. Turner, but it doesn't apply to the facts of this case. First, the trial court's order following this court's remand discussed the Turner decision was decided after it set aside the default judgment, and it was inequitable for it to apply that doctrine to its actions, which did not exist at the time. To the extent that this court may apply the exceptional circumstances doctrine, the appellant has not demonstrated that it was entitled to relief because Martha Bain did not suffer any prejudice or present any reasonable reliance upon the entry of the default judgment. This court must find that the party seeking relief after having actual notice of the judgment manifested an intention to treat the judgment as valid, and granting the relief would impair another person's substantial interest of reliance on the judgment in order to deny setting aside a default judgment. John and Ann Bain's appearance was limited to challenging an assessment of costs against them. They didn't manifest any intent to treat the judgment as valid when they appeared in the 2008 case after the judgment was entered, about 16 months after the judgment was final. The only argument that the appellant raises concerning Martha Bain's reliance on the entry of the default judgment is Martha Bain's desire for repose from legal controversy. Appellant's argument, it falls short because Martha Bain nevertheless filed a 2014 lawsuit concerning the same parties, the same property, and evidently the repose from legal controversy wasn't a valid concern for her. And Martha Bain's reliance on any default judgment is not supported by a reliance from legal controversy because and the record on appeal contains no other evidence on the entry of default. So since the exceptional circumstances doctrine doesn't apply, the court should look to the meritorious defenses that John and Ann Bain raised in order to set aside the default. In this case, the appellant failed to issue any summons in the 2008 case. The appellant attempted to serve John and Ann Bain via publication, even though appellant knew where they were and who they were, in violation of Tennessee Code Annotated 21-1105. And the appellant failed to follow procedural requirements for publication because the complaint wasn't verified. The trial court found that all these factors constituted a meritorious defense, and it was proper to set aside the default judgment. And so for these reasons, it did not abuse its discretion. The trial court also found that Kendry was an indispensable party and that complete relief under Rule 19.01 could not be awarded in his absence. The complaint was essentially for rescission of the deed, and since Tennessee recognizes that a holder of a deed of trust is vested with legal title, the clerk and master's deed could only convey back to Martha Bain equitable title to this property. And so in the absence of Jayon Kendry's presence in the first lawsuit, the judgment did not provide complete relief among the parties. One of the issues that appellant has raised is the exclusion of Martha Bain's deposition testimony. The trial court properly found that under the rule of completeness, Martha Bain's testimony should not have been admitted into evidence because it was only partially complete, despite efforts over many years by John and Ann Bain to take the full deposition. Under Rule 32.014, if only part of a deposition is offered into evidence by a party, an adverse party may require introduction at that time of any other part which ought in fairness be considered. And in the absence of a complete deposition, there was nothing that John and Ann Bain could have offered into evidence to rebut any statements that were made in the deposition. It was also excluded as a discovery sanction. The record is replete with attempts by John Bain and Ann Bain to take the complete deposition of Martha Bain. There were motions to compel, motions for sanctions, which the trial court did order, and ultimately the deposition never occurred prior to the trial. And so on these bases, the trial court excluded her deposition. This is proper and was not erred by the trial court. Now I want to discuss the power of attorney. The appellants argued that the existence of the power of attorney alone essentially gives rise to this confidential relationship, which gives rise to the presumption of undue influence between John Bain and Ann Bain. This is contrary to Tennessee case law, which under Childress v. Curry provides that an unexercised power of attorney does not give rise to a presumption of undue influence or a confidential relationship. And in this case, there is no evidence in the record that John Bain ever exercised the power of attorney before the October 28th, 2003 deed was executed. There was discussion of some conveyance of property, but no time was discussed before the trial, and no deed was ever entered into the record showing when John Bain may or may not have executed a deed on behalf of Martha Harrison Bain. And so because there's no evidence indicating that the power of attorney was exercised, there's no confidential relationship on this basis. The appellant also attempts to argue that the familial relationship between John Bain and Martha Bain gives rise to a confidential relationship. But there's just no evidence to prove that John Bain ever exercised dominion or control in his role or in his relationship with Martha Bain. The only disinterested witness at the trial, Thomas Bain, testified as to Martha Bain's actions in directing John to manage her business dealings. Thomas Bain also testified that Martha Bain was aware of what the import of the 2003 deed and agreed that she intended to convey the property to John Bain in 2005. 3 years before she filed the first lawsuit. John Bain testified that when she began conveying her real property to all of her children, not only to John Bain, that he had nothing to do with those deeds and those decisions were made by herself. All of this testimony indicates that John Bain's actions were made at Martha Bain's direction within her sound mind. There's just no evidence of dominion or control that Martha Bain failed to establish a confidential relationship between herself and John Bain at the trial. And finally, even if there was a presumption of undue influence and the trial court erred, our clients properly rebutted it by the submission of evidence that the transaction was fair to Martha Bain. As the trial court correctly noted in its ruling, there was clear, convincing, and overwhelming evidence that the transactions were fair. The trial court did find it important to its ruling that Martha Bain was in the process of deeding much of her property away to all of her children, not only John Bain. The evidence indicates that Martha Bain was aware and in control of her actions, and the fairness is shown circumstantially by the gifts of the real property to all of her other children at the same time. Appellant argues that the failure to record the deed somehow shows a difference between these transactions, but John Bain's failure to record the deed doesn't have any impact on the fairness of the transaction to Martha Bain. The recording statutes are only designed to protect subsequent purchasers. It didn't indicate that somehow the transaction was not fair because John Bain didn't record the deed as immediately as his siblings. Addressing the appellant's argument that this court should consider lack of independent advice that as it raised in its brief, proof of independent advice becomes only necessary when it would be difficult to show the fairness of the transaction or the competency of the testator without it. And that's Court of Appeals opinion in the matter of Dupree's estate. Martha Bain's competence is shown by her various gift deeds, which she did not require John Bain's help, and he testified that he had nothing to do with this, to all the other children. The fairness is also shown by the gift deeds to the other children. It shows that Martha Bain intended to start disposing of her property, and that this one conveyance to John Bain was no more unfair than any of the other conveyances to the other children. In the absence of any other circumstantial evidence, which is not before this court, there's just no suspicious circumstances, and Martha Bain failed to carry her burden of proof to demonstrate that that she was unduly influenced in transferring this property to John Bain. Thank you.
Okay, thank you very much. You have your rebuttal, sir. Let's see, your mic is on mute. Want to unmute it?
Thank you. Thank you for that reminder. Upon reflection, I think I may not have answered the court's last question in full, so I want to address that first. And the question was whether what influence John Bain had in relation to the execution of the warranty deed that's in question in 2003. So this is what the testimony at trial proved. First off, John Bain contacted an attorney in Newport for purposes of preparing the warranty deed to the real property, the one that was conveyed to him and his wife. So he's the one that had that deed prepared, and we say under the proof that does not fit the pattern of what was happening in relation to the other transfers. Two, when it came time to execute the warranty deed, that execution was done in Virginia, not in Tennessee. It was done in Virginia, and John Bain drove his mother to the attorney's office where the deed was executed. Now, he says that he didn't go in, but he also says he doesn't know if the attorney was there and doesn't know if Martha Bain was given any independent advice. So Martha Bain was unable to drive at that time. She was reliant upon her son, John Bain, for care. And so what we say is, yes, he was instrumental in causing that warranty deed to be executed, and it did not fit. For that reason and other reasons, it did not fit the pattern of what was going on with the other properties. But it also goes back to the lack of a finding of a confidential relationship. And what the cases say is that if there is an unrestricted power of attorney in and of itself, that constitutes a confidential relationship. That's the Supreme Court's Matlock versus Simpson case. Now, the follow-up case to that, the Childress versus Curry case, says if that power of attorney is unexercised, that in and of itself does not create the confidential relationship. And that's why we say it's important for the court to look at the facts of whether that power of attorney was exercised. And here's what the facts show. The deed in question was executed on October 28th of 2003. Mr. John Bain testified that he used the power of attorney one time, and that was to sell off a piece of property. There is a check dated October 17 of 2003, just immediately before this warranty deed was signed, and he negotiated that check. That was a check that was made to Martha Bain, and he said that that check was for purposes of selling a piece of property. And then, and this I think is key, the power of attorney itself was recorded on October 23rd, 2003 in the offices of the Cook County Register of Deeds. That was 5 days before the execution of the warranty deed that we're seeking to set aside. So we say the proof does show that, yes, the power of attorney was exercised. Thank you.
Thank you very much. Your case has now been submitted to the court. I understand that there was a motion filed to strike some matters in a responsive brief that will be considered by the panel and addressed at that time. Now, is there anything further on this matter that we need to consider? If there's not, then Mr. Clerk, will you count that joint court?
This honorable court is now adjourned.
Thank you. The attorneys